so.
Good morning. Day 2 of the California Board of Accountancy meeting. I'm Michael Savoy, the president. Let's go around the room, starting with Kathleen.
Kathleen, right? Sochi Leon.
Jose Campos.
Dan Jacobson.
Alicia Burhow.
Mark Silverman. George Familar.
Michael Savoy.
Carola Nicholson.
Luz Molina Lopez.
Thank you. We have a quorum. Let's start today with the Executive Officer Report.
And I'm going to invite Aaron to come up and give the communications report.
Good morning, Mr. President and board members. I'm happy to provide some brief comments about our recent outreach activities. On February 28th, Mr. Campos joined the CBA staff as we traveled to California State University at San Bernardino, where we spoke to more than 100 students and faculty. What helped to make this event unique is that the faculty at Cal State San Bernardino also invited colleges from within their region to attend this event. So some of those 100 plus attendees were from Cal Poly Pomona, the University of Redlands, and UC Riverside. Ms. Kathy Johnson, the current Cal CPA chair, is a professor at Cal State San Bernardino, and she and others from the school, as long as Cal CPA, were instrumental in helping making this event highly successful. Then on March 10th, Mr. President, we were fortunate to have you attend a consumer outreach event at Crenshaw High School in Los Angeles. At this event, the CPA spoke to consumers about license lookup and offered tips to select a CPA that would be suitable for their needs. This event was sponsored by Karen Bass, a member of Congress who represents portions of Los Angeles. Looking later into the spring, on April 17th, President Savoy and staff will travel to Cal Poly San Luis Obispo to speak to the Cal Poly Accounting Club. There we will speak about the requirements for licensure with a particular emphasis on the requirements to sit for the CPA exam. On that same day, the CBA will, for the third year in a row, join the California Department of Business Oversight and other state agencies and nonprofit organizations at their California Financial Literacy Month Resource Fair. This is held at the state capitol grounds. At this event, we share our consumer assistance booklet with attendees. This booklet discusses our mission, the role of the CPA, and offers tips to select one for your needs. Finally, in the last couple of weeks, I confirmed that the CBA will be holding an event on the campus of the UC Extension campus at San Diego, the UC San Diego, that is. Students at this program are typically those who are already in the workforce but are returning to complete some education to be able to qualify for licensure. This event will focus on the requirements for licensure. The year is off to a busy start, Mr. President, and this concludes my remarks.
Thank you. Any questions, comments? Thank you so much. We're going to flip to item number 10, letter D, report from the EPOC Committee. Mr. Silverman.
Thank you, Mr. President, and thank you for fitting me in at this time slot. The EPOC Committee met yesterday, and I'd like to give you an update regarding violations of Title 16, California Code of Regulations, Section 87A1, minimum annual continuing education requirement. Staff reported that the purpose of this agenda is to provide the CBA with information regarding implementing CBA Regulations 87A1, also referred to as the 2012 requirement. The 2012 requirement mandates licensees complete a minimum of 20 hours of continuing education in each year of the 2-year license renewal period with a minimum of 12-hour subject areas. This requirement took effect back in January 2010. The 2012 violations are identified in the renewal unit at CBA. For first-time violations, the renewals unit notifies the licensees of the requirement and informs them that future violations are referred over to the Enforcement Division. Enforcement referrals may warrant an additional letter or the issuance of a citation and/or fine. Going forward, staff will have all license renewal applications identified for violation of the 2012 requirement to be referred to the Enforcement Division. Violations will be reviewed on a case-by-case basis to determine if a warning letter or other enforcement action is warranted. The EPOC did not take any action on this item, and I know Mr. Franzella is here and would be able to take any detailed questions about this 2012 requirement. Thank you.
Thank you. Any questions, comments? Thank you, Mr. Silverman. We'll now jump to back to item 7, letter B, a report from the meeting that the Qualifications Committee had. Gina's going to sit in for David Evans.
Yes. Thank you. Good morning.
Let's wait for your name. There you go.
All right. Good morning. This is the report on the Qualifications Committee. Good morning, members. I'm here today to report on the QC, which is what we call the Qualifications Meeting, that was held on January 24th, 2018 here in Irvine. There was also a subcommittee held a week prior on January 17th at the CBA offices in Sacramento to accommodate those living in that area that month. So at these meetings, there was a total of 10 Section 69 reviews and 2 personal appearances. Out of those, 10 were recommended for approval for CPA licensure, and 2 were deferred to come back to another meeting if they submit another experience form to the CBA. The Qualifications Committee next meeting will be on April 25th at the CBA offices in Sacramento. That concludes my report. If there are any questions, I'd like to turn it over.
Thank you so much. Anybody? Questions? Appreciate you sitting in. Or standing in, as the case may be. Report of the Enforcement Chief, Mr. Franzella.
Thank you and good morning. So item 8A is the enforcement activity report, and in the meeting materials it covers 7 months of data as of January 31st of this year. Excuse me. Excuse me, I apologize. Pages 1 and 2 of the report cover complaints received and complaint information. Year to date, we have received just over 1,200 complaints. I've been informed by the renewal staff, though, there's a volume of referrals set to come over if they haven't already come over to the enforcement division. So that number will likely jump by the time we come back in May to report to the board. Moving on to investigations on page 3. Page 3 shows that a total of just over 1,300 investigations have been closed for this fiscal year, indicating the number of cases being closed outpaces the investigations that have been assigned. Of the 1,300 investigations closed, 831 investigations were closed within the first 6 months, accounting for 61% of the total number of investigations, and additionally, just over 1,000 were closed within 1 year, accounting for about 79% of the total number of investigations closed. We have experienced a increase in the average days to close, but that is more related to as we clear the aged inventory. That number continues to go up, but it is down slightly from the last time I reported. On page 4, this provides an inventory of the investigations pending based on the age of the case. It looks like nearly 60% of the division's cases are less than 6 months in age, and almost 80%, or just over 80%, are less than a year old. As of January 31st, the CBA has 60 cases pending over 24 months. This was a significant decrease of the inventory when we compared it to the end of last fiscal year, which I think was like about 115. And at the last board meeting, the inventory was at 72, so we've been able to reduce that by an additional 12 cases. Moving on to pages 6 through 9 on discipline. The CBA has referred 57 matters to the AG's office, which is a similar pace to last fiscal year. At the bottom of page 6 and on page 7, working closely with the AG's office, the inventory of matters pending continues to decrease. At this time, the last fiscal year, we had 99 matters. At this point now, we only have 80. The number of cases over 24 months is now only at 2. One has been on the report since Raphael, before Raphael was probably, I mean, it's 2012, I want to say. And the other one is something we're working closely to get either set for hearing or reach settlement on. On page 8, provides information on final orders. Through January 2018, the CBA had taken disciplinary action on 57 matters, and another 15 took effect shortly after this report was issued. Lastly, on page 9, this is information regarding cost recovery. As of January 31st, the CBA had ordered cost recovery in 34 cases amounting just over $261,000, representing about 63% of the approximate investigative and prosecution costs. Page 10 of the report covers citation and fines. Over the first 7 months, the CBA has issued 75 citations. We've seen a decrease in the average day, an increase in the average day to issue citations from 222 at the last report to 245, and this increase is attributed to 21 age cases that recently concluded. Without those cases, the average day would be about 133. Moving on to page 11 with FTB and probation monitoring. For the fiscal year so far, we referred just over $10,000 to the Franchise Tax Board and collected $250 on outstanding fines owed to the board. And on probation monitoring, the number of probationers is continuing to grow. We're at 164 probationers. And we've added some additional information related to the number of orientations we've held and how many are outstanding. Initial orientations, we had 15 initial orientations as of January 31st. I believe they took care of 9 of them just right after this report was issued, so the inventory of people who haven't had their initial orientation is pretty low. And lastly, members will note that the mobility information that used to be in the report is no longer there. That is now in it's an agenda item, I want to say it's 10B 3 on the mobility activity report. So all mobility-related enforcement information has been transitioned over there. This time, I'm happy to turn it back over to President Savoy, and I'm happy to answer any questions you may have.
Questions? Comments? Jose?
Question on the investigation, what is this, complaint types? Page 2, you had a category of accounting license database items in the prior years, but that's not in the current year. Did that just go away or get folded into another category?
I think it probably got folded into, I want to say, the other category, but I'll double check and report back to members at the meeting, just to make sure.
What are accounting license database matters?
That's the State Board of Accountancy side of CPA Verify, and we get a list, generally it's once a week, sometimes more, of ALD issues that have come up that can range from anywhere from a licensee being canceled to some type of revocation or disciplinary matter taken in the other state. So we compile those so we can validate what that information is. And those are individuals who have a license both in California and in another jurisdiction where there's some type of hashing that allows them to come over to the board to evaluate.
Okay. And then on probations on page 11, so I see the line item for referrals to, revoke probation or reevaluate that. Is that indicative of the totality of probationers who maybe aren't complying with their terms? Or is there a brewing number in here that, might result in that?
Yeah, so we've recently added this particular line item, the referrals to revoke probation, and one of the other things we're going to be doing is adding information on the violations we have. So the violations we've identified during the course of the fiscal year. So we may identify a violation and work to correct it, but it's only when we get to that point of they're no longer complying with probation that we can't get correction that we'll refer it over. And I think there may be an inventory of that coming. So I'm trying to get it before the board so you all can see that information.
Questions? comments? Thank you. Yes, I'm sorry, Mr.
I just had one. Mr. Franzella, looking at page 2 of your report, and it looks like last year and this year are tracking in the same range for convictions and subsequent arrest, but 2015-16 has triple the percentage. Was that just an anomaly that year or what?
That existed for about, I want to say maybe if you go back to 14, 15, and then maybe even 13, 14, it was the retroactive fingerprinting and getting all those individuals. So we had a significant volume of cases, and tracking back, as you can, if you go back on looking at our number of complaints, at one point in, I think it was 14, 15, I think we had about 3,200 complaints, and a lot of that was as a result of that retroactive fingerprinting.
Thank you very much.
Absolutely.
Any other questions? Thank you so much.
Thank you.
Report of the licensing chief, Gina Sanchez.
Good morning again. All right, I'm here to present the licensing activity report, which reflects statistics through January 2016. Page 1, of course, we start with our total CBA population with 104,580 licensees and registrants. Moving on to page 2, this reflects the amount of contact staff have had with our stakeholders, beginning with telephone calls and emails received. The bottom chart of this page shows requests from stakeholders for certification of CBA records relating to license status or CPA exam scores. The unit is currently processing these requests at 23 days from receipt. Page 3 begins the statistics related to the CPA exam, separated first by first-time exam takers and repeat sitters. Just to add some clarification, repeat sitters are not always those who have failed a section. It also includes those who may have passed a section or two on their first sitting and are moving on to their next sections. In the first 5 months of this fiscal year, we have approved just over 3,500 first-time candidates and over 9,300 repeat candidates. Currently, there are 561 applications that the CBA has deemed deficient. These applicants have been notified that their application could not be completed until we receive additional information. We consider these applications incomplete, and the time frame is considered outside of board control. Moving on to page 4, identifies the number of and processing time for requests to extend a notice to schedule to take the exam or to extend a score for a section that's about to expire. Additionally, statistics are captured for the number of individuals who request and were approved for special accommodations in order to sit for the exam. Page 5 begins the statistics for initial licensure. So far this fiscal year, we have approved almost 1,500 applicants for licensure, of which 380 were given the authority to sign attest engagements. Speaking of the attest authority, I would like to bring your attention to page 6. At the March 2016 CBA meeting, the results of the attest study were presented and discussed. This study was to gather feedback to assist the CBA in determining if the 500-hour attest experience requirement was necessary and sufficient to support the CBA mission to protect consumers. It was concluded that the 500-hour attest experience requirement is sufficient for CPA licensure, and during the discussion, the CBA had directed staff to increase outreach efforts, periodically evaluate the experience requirement if necessary, and to watch for changes in other states' attest experience requirements. The attachment 1 to this agenda item provides information on these directives. Staff have determined that no significant changes have occurred that would warrant any changes to the CBA's attest experience requirement. Going back to the agenda item, page 7 continues with initial licensing. So far this fiscal year, 123 California accountancy firms have been approved, and 24 out-of-state firms have been approved for registration. I want to stay with this here. Beginning on page 8 begins the renewal-related statistics. The top of the page reflects the total number of licenses that have been renewed so far this fiscal year. The second chart identifies that out of those renewals, a significant number have been reviewed by staff. Currently, over 23,000 renewal applications that have been reviewed so far this year. About 4,000 have been identified with some type of deficiency, and we have also complied out another 4,000 after receiving that additional information. Page 9 identifies our retired applicants and begins our division highlights, which I will highlight just a couple. The first bullet refers to the second attachment, which is the NASBA CPA exam performance summary for the fourth quarter, or Q4. This attachment is 2 pages front to back, the first being a California-specific report and the second being an all-jurisdiction report. I try to include these frequently so you guys will recognize those. As of April 1st, the CPA exam will now include Microsoft Excel, a larger monitor, and a new online workspace for candidates. That concludes my report. I would now like to turn it over to the president. Happy to answer any questions.
Questions? Yes, Kathleen?
One quick question, and thank you again for the CPA exam performance statistics. The highest pass rate for all jurisdictions on, let's see, next to the last page, continue to be the same states. And I was just curious if we have any insight as to why they do so well. We don't do poorly, but we are in the bottom half.
We have reached out to NASBA. They are telling us that they're gathering information and going to get back to us. We have not received comment yet, but as soon as we do, we'll be providing that to Ms. Bowers, and whether we bring it here or provide it to you under separate cover or all under separate cover. But yes, we are definitely looking into that. Thank you. You're welcome.
Any other questions?
Yeah, real quick, on page 3 at the bottom of the chart there, it looks like, so basically we have fewer and fewer applicants, either first time or repeat. Is there a trend then that we're seeing?
For first-time sitters?
Yeah, or just combined total going down over the years? Is that a trend that's been going on?
That is something we have been looking at, that the first-time sitters, we have noticed over these past, I guess, several meetings that the trend is going down just a little bit. That's another reason we reached out to NASBA again to try and find some information as to why. I also work with, Cal CPA, and they're also have informed me that they're looking into why first-time sitters, they're just not getting in that seat. We see them at college outreach events, and we try to, help them through the process as much as we can, show them how easy it is to get through CBA and such, but we still are seeing that trend, and we've really been pushing that outreach for probably over a year or more.
Yeah,
So we're not seeing more.
yeah, if you wouldn't mind sharing when you do get some more data, if there's any broader trends, whether it's from NASBA or Cal CPA, I'd be interested to understand what those trends are.
Yes, absolutely.
Any other comments, questions? Thank you so much for your report. Moving along, item 10, A, Committee on Professional Conduct. Alicia.
All right, thank you, Mr. President. The Committee on Professional Conduct met on March 22nd, 2018. Item 10A2, we had a discussion and possible action to initiate a rulemaking to amend Title 16, California Code of Regulations, Sections 87 and 88, continuing education rules. So the purpose of this agenda item was to provide an opportunity for the CBA to consider taking action to amend CBA Regulation Section 87A2 to include 4 additional technical subject areas and CBA Regulation Section 88H to increase the allowable continuing education credit for specified activities. So the CBA discussed the model rules for continuing education, or rules, at its January meeting and directed staff to draft regulatory language to amend the relevant CBA regulations. So we do have one motion from our committee. So the CPA recommends that the CBA approve the regulatory text in CBA Regulations Section 87A2 and 88H, which should show 50% as underlined. Direct staff to submit the text to the Director of Department of Consumer Affairs and Business and Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. That is my motion. The committee motion.
Do I have a second?
I don't think we need a second.
Oh,
We just need a,
we need a vote. Any comments?
yeah.
Didn't we vote on this yesterday?
Yeah,
At
the
the
committee
committee
did.
level.
Oh, the
The committee did.
It has to come to,
Has to come to the board.
Okay, thank you.
here's the real power.
I know, this is it.
No comments, no public comments.
Alicia Burhow,
Yes.
Jose Campos.
Yes.
George Pamela,
Yes.
Dan Jacobson.
Yes.
Sochi Leon.
Yes.
Luz Molina Lopez.
Yes.
Roland Nicholson.
Yes.
Michael Savoy.
Yes.
Mark Silverman.
Yep.
And Kathleen Wright.
Yes.
Okay.
Motion carries.
All right, continuing on, 10A3, we had a discussion regarding the National Association of State Boards of Accountancy, model rules for continuing professional education, Article 3, and possible changes to Title 16, California Code of Regulations, Section 87, basic requirements for continuing education. So the purpose of this item was to provide the CBA an opportunity to review and discuss the CBA's ethics continuing education, or CE, requirements when compared to the NASBA's model rules for continuing professional education. At its January meeting, CBA members discussed this topic and requested that staff provide more information regarding the NASBA fields of study that qualify for continuing professional education. Upon review, staff determined that the CBA regulations encompass many of NASBA's model rules subjects relating to the ethics, with the exception of sexual harassment, workplace harassment, and workplace violence. So staff also determined that CBA regulations have a thorough definition of ethics that align with NASBA's rules and include varying subject matter, which allows licensees several options to complete CBA's 4-hour ethics requirement. So staff stated that the ethics requirement was originally put into CBA regulations by a task force which decided that sexual harassment prevention, workplace violence, or workplace harassment did not meet the overriding consideration, and determined that the programs do not contribute directly to the professional competence of a licensee in public practice. This was an informational item only, and the CPA did not take any action on this. Does anyone have any questions?
Thank you.
All right, and I have one more item. I'm going to breeze through this. Item 10A4, information regarding regulatory oversight responsibilities related to legalized cannabis. The purpose of this agenda item was to provide the CBA with information regarding the regulation of legalized cannabis. So staff reported that over the past several years, 12 boards of accountancy have issued information regarding providing services to businesses in the cannabis industry. So the statements issued by the various boards of accountancy appear to provide, in essence, a comfort statement regarding providing services to clients in the cannabis industry. The issue of the CBA providing a comfort statement has been raised by licensees. The CBA does not issue such statements, so further statements such as those offered by other boards of accountancy in fact operate as legal opinions. So in California, the California Attorney General is the sole agency that provides legal opinions to designated state and local public officials and government agencies on issues arising in the course of their duties. So presently, when the staff are contacted by licensees inquiring about the CBA's position regarding providing services to clients of the cannabis industry, staff inform them that the CBA has no position and that they need to consider and possibly seek legal counsel to assess the risk factors and make their own assessment on whether to engage with clients in the cannabis industry. But we did have a motion, and this is a fully formed motion from the CPC committee, and we recommend that the CBA direct staff to monitor the progress associated with the regulation of cannabis, keep the CBA apprised of any significant issues impacting the CBA, the accounting profession, or the CBA's consumer protection mandate, and convey, as appropriate, the information to other regulatory agencies.
Comment, Kathleen.
Thank you. I do disagree with the report that we received from CBA, and I will explain why. And secondly, I disagree with the recommendation of the motion to limit our involvement with this issue to quote monitor. And allow me to explain. First off, with respect to the specifics of this report and the statement that we do not issue a comfort letter, I did look at CBA's rules, regulations, and the statute and could find no prohibition against issuing such a comfort letter, point one. Point two, the conclusion that issuing such a letter would be a legal opinion is, in my view, not correct. That would not be a legal opinion. It would not constitute the unauthorized practice of law. And I'll be glad to go on and explain that position if you would like. Thirdly, by not issuing such assurance, as have these other 12 boards of accountancy, to their constituency, I believe that we are doing a disservice to the public. The public is the public that is now legally trying to offer the cannabis product to the voters of California who voted in Prop 64 that this is what they wanted. Secondly, the disservice, in my view, I think we also have a very high level of requirement to the CPA community. And leaving them out there without any assurance that we would not take action against them directly for, as an example, preparing a tax return for a cultivator, manufacturer, distributor, or retailer involved in this industry, I think does a disservice, particularly to the small to medium-sized practitioner, who is the one that most of this business activity is being addressed to. The licensing, the Bureau of Cannabis Control at the moment is not issuing licenses, because they can't under their statute, to large cultivators and manufacturers. The only licenses that are being issued are to small to medium-sized, and it's 4 categories: cultivator, manufacturers, distributors, and retailers. That being the case, this is not really a Big Four type of an issue. This is a small to medium-sized practitioner issue. And the practitioner knows that they can provide a service. As an example, and this is only one of several, 2 questions faced by this industry of people who are expert in what they do, but they typically don't know anything about accounting or tax, is the following. Under Proposition 215, which authorized the legal use of medical marijuana or sale of medical marijuana, these businesses were required to operate as not-for-profit, and the category under Section 501 of the Internal Revenue Code was joint stock mutual company. That is not a charitable organization. That's like the Chamber of Commerce. They provide service to their members, but they had to be not-for-profit by statute. Now, under Proposition 64, they are allowed to operate for profit. And they want to do that. And they come to their CPA, who is the closest connection they have to professional advice. Most of these small businesses don't have lawyers. And they say, how do I convert from not-for-profit to for-profit? I can tell them that. It's 2 ways. They can do a conversion. I can tell them exactly how to do it. And they can do a Type A statutory merger under Section 368, and if you do it right, it's tax-free. And I can tell them how to do that. They have no idea how to do this. So that's point 1. Point 2, they come to file their tax return. For federal purposes, there's a code section enacted many years ago called Section 280 Cap E. And under 280E, these businesses are categorized as drug dealers, Tier 1 controlled substance, and marijuana fits into that category. So they're under 280E. Congress doesn't like drug dealers, so Congress said, because of a very old Supreme Court decision, you have to allow the taxpayer to deduct the cost of goods sold. And so Congress said, fine, but we don't have to allow them to deduct trade or business expenses, and we're going to disallow that. So what is a trade or business expense versus a component of cost of goods sold? I know how to answer that question. I've got a chart of all the costs. Cost capitalization is one of the things that I do. I can tell you exactly how to do your return and comply with 280E. But that's not the end of it. You then have to file in California. And in California, we got 5 statutes that deal with tax. One of them is the personal income tax. And if you're set up as a sole proprietor, so you're filing a Form 540, you're under 280E, you cannot deduct a trade or business expense. But if you incorporate and you're filing under the corporate tax law, we don't conform to 280E, and you can deduct everything. So when you are trying to do this conversion, let me help you with the choice of entity question and get you set up as a corporation so that your tax position will be much better. I can do this,
One second.
but
I mean, if
I'm
this
not
is a
allowed.
commercial that you can do all of this work for that industry
No,
versus...
because I don't
So-
actually take clients, but
Oh.
the bottom line to this is in these seminars, the question that I'm getting is when is CBA going to come out and give us some sort of guidance on on whether or not we can take these clients, just take the client. What's not in the material that we received is the white paper that was put out by AICPA and by NASBA. And in that white paper, it made it crystal clear, which is absolutely true. You're not doing anything wrong if you just simply do a tax return for somebody who's operating an illegal business. It's taxable income, we want the money, and somebody's got to file the return. And therefore, for us to say, to not provide guidance in the context of what you're referring to as a comfort letter, to give the CPA just the assurance that we're not going to revoke a license just because you do a tax return for somebody who's a marijuana cultivator, to me is not providing a service to the public. It certainly is not providing a service to the industry. And then I have a question. If these 12 other boards of accounting saw fit to give this kind of a, quote, comfort letter, then what's holding us back? I mean, we should be at the forefront. We're one of the 9 states that legalized adult recreational use marijuana. And we should be out in front of this issue. We shouldn't be sitting in the back waiting for what? I mean, what are we waiting for before we issue some sort of guidance? And you say it's not something that we routinely do. Well, cannabis is not a routine issue. It's relatively infrequent that you have a federal statute that bars an activity that 9 states have now legalized. More than half of the states have legalized medical marijuana, and 9 of those states have gone forward with adult use of marijuana as well. So I'm done.
Yes, Dan?
If I may start with one of your last comments first, that let me just state this. I don't think we were talking about a comfort letter. We were talking about, I think the nomenclature was a comfort position or something along those lines. Number 2, I wanted to mention that courts take, as I believe you know, are greatly deferent to agencies that are given the responsibility of enforcing certain issues, so that a court should be deferential to the CBA on accounting issues. If we have a position, it may not be entitled legal opinion, but ultimately it can be adopted as one in a court opinion. Anything that we give that is not mere puffery, any position that we give that is not mere puffery, I think will necessarily be somewhat convoluted because the laws between the 2 sovereigns, California and the United States, are different. And therefore, whoever is left whoever lives in both sovereigns, California and the United States, and are obligated to follow the laws of both sovereigns have a difficult issue to face. And frankly, they need to see a lawyer about it, and my guess is that a lawyer's opinion will say, this is kind of the best you can do, or this is kind of the worst that you can do. And for us to give this is kind of the best you can do, this is kind of the worst you can do position is problematic, because we're supposed to tell them what they can do and what they can't do, and we can't here. We can't do it, and therefore I fully support
clearly,
the position.
if you prepare a tax return or a financial statement in this industry, I don't think the board or the accounting profession in California has an issue with servicing a client. The crossover is all of a sudden the federal government comes in and goes after you because they decide to go after all providers of service to that industry in California.
Yes.
That's why we've hesitated until the federal government gets more clarity of how they're going to treat these things. We're not telling accountants they can't do it, but we're also not telling them, and that's why I think they're telling them to go to a lawyer to see what happens if that, uncle whatever comes after you. So that, I think that's where the divide is. These people just come out and said, sure, it's okay if you do that work, but beware that there's somebody else that may come down on you. So, I'm not telling you to bury our heads in the sand by doing nothing. I think more time has to unfold. We're taking all the questions that are being asked of CPAs that call and kind of funneling them to see if we can get some consensus.
Two things, and Dan, thank you for your comments. The word comfort letter was not a word that I should use. The statements by these boards are in the materials, and they don't say anything more than essentially what is within the purview of our authority, which is suspension and revocation of a license, is not something we would do simply because you provide services to the cannabis industry. They do typically, such as Oregon, go on to say that if you get a federal indictment and there's litigation and you're held guilty as an accomplice or co-conspirator or whatever of selling marijuana to a minor or whatever the offense might be, then of course we would revoke or suspend your license because you've got a federal judgment against you, which pertains to character and morals and all that kind of thing. That's all they're saying, and I think that's totally, and that's all the practice or the CPA practitioners are seeking, is that they won't be subject to revocation or suspension simply because they provide this service. Now, the result is, right now, if you want to know, these small firms are telling this industry they're not performing these services. We're not going to do your tax return, and we're not going to do any accounting work for you, and we're not going to help you convert from profit to, or not profit to profit. So here we are. The industry is not getting banking services, and they're not getting accounting services. So what are you going to suggest to this industry, and how do you define the position of not giving them at least the assurance that they can do this kind of work without the risk of revocation and suspension? How do you define that as service to the public when we're turning our backs on
Ms. Wright, may I interrupt, please?
Yeah,
we're
go ahead.
repeating what's already been put on the record.
That's right.
I think so. So unless there's something new, I would say we probably
Yeah, we
don't need to
we have
repeat and
yeah,
rehash.
there's no more comments. We have a duly formed motion.
I just, one clarifier though is, in our deliberations at the CPC, what I understood was the advice of counsel and staff was that we are not in a position to provide these comfort statements or opinions because that's the job of the Attorney General's office and it's outside the purview of what this board can do. Did I understand that deliberation correctly?
That's how I understood that, correct. That's how I understood that deliberation when we were
That
going
was
through.
the understanding that we had in coming through the dialogue in the CPC. Does it move?
I believe you are correct in that. Actually, I will say that The most I will say is that board staff and the board in general should not be giving legal advice of any kind, regardless of whether it's the duty of the AG's office or your DCA legal counsel, who's me, to give the advice. We don't give advice to the public because we don't want to create an attorney-client relationship with any member of the public, whether it's one person or all of them. Our client is, my client is the board, Carl's client is the complainant at the time of whoever's the EO at the time. So that is my reason for not giving this sort of advice or writing a comfort letter of some sort, is because of the attorney-client relationship, and we just don't give legal advice to the public.
Okay.
All right, we've taken this far. We've heard your concerns.
I have one more
We're not banging
concern.
our head. We're done.
Okay.
We need to put this to a vote and move on. Please.
Dan Jacobson,
You forgot the motion.
What is the motion?
Oh, the motion, I will repeat it. The Committee on Professional Conduct recommends that the CBA direct staff to monitor the progress associated with the regulation of cannabis, keep the CBA apprised of any significant issues impacting the CBA, the accounting profession, or the CBA's consumer protection mandate, and convey as appropriate the information to the regulatory agencies.
Yes.
Sochi Leon,
Yes.
Luz Molina Lopez.
Yes.
Corolla Nicholson,
Yes.
Michael Savoy.
Yes.
Mark Silverman,
Yes.
Kathleen Wright,
No.
Alicia Burhow.
Yes.
Jose Campos.
Yes.
And George Family.
Yes.
Thank you. Motion passes.
With that, I conclude my report.
Thank you. Let's move on to Sochi giving the Legislative Committee report.
All right. So moving on to an update on our discussion on the Legislative Committee yesterday, March 22nd. First item, we reviewed the California Board of Accountancy 2018 Legislative Tracking Chart. Then we moved on to a number of bills with several positions. I'm going to try to go as fast as I can with them. Can you guys hear me?
Okay, thanks.
We're good? Awesome. So AB 2087, State Government Operations, Technology Modernization. This bill would require each state agency to establish modernization goals by 2020. Currently, the CBA, in conjunction with DCA, has begun a business modernization project to identify IT solutions in the automation of its examination, licensing, and enforcement activities. The Legislative Committee recommends that the CBA take a watch position on this bill, and that was a fully formed motion.
Any comments? Questions? Public comments? Call for a vote.
Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Michael Savoy.
Yes.
Corolla Nicholson.
Yes.
Luz Molina Lopez.
Yes.
Sochi Leon,
Yes.
Dan Jacobson.
Yes.
George Pamela,
Yes.
Jose Campos.
Yes.
And Alicia Burhow.
Yes.
Motion carries. Next item.
AB 2138, Licensing Board's Denial of Application, Criminal Conviction. This bill would prohibit a board within the DCA from denying a license application based solely on an applicant's conviction of a non-violent crime. Currently, the CBA may deny a license on the ground that an applicant has been convicted of a crime, done any act involving dishonesty, and any act that would be grounds for suspension or revocation. Staff stated that if enacted as currently drafted, the CBA may incur unknown and possibly significant expenses to determine whether applicants convicted of nonviolent crimes should be denied licensure. Since 2010, CBA has denied 47 applications for licensure pursuant to Business and Professions Code Section 480. Only 9 denials during that time were related to the conviction of violent crimes. Senate Business and Professions Committee Chair Assemblyman Lowe, one of the authors of the bill, conveyed to the DCA their interest in receiving input from boards to help improve this bill. The recommendation from the committee is that the CBA take a watch position on this bill.
Any
Fully
comments?
motion.
Questions?
I mean, I know there was debate at the committee level about why wouldn't we oppose this like we did last time, right? And it seems like we think we could work with the author to do that, but I heard the discussion, but we think a watch will provide us enough communication to the author's office on this, as opposed to like an oppose unless amended type of position.
I like that idea, actually.
Yeah, I mean, I brought that up yesterday when I sat in on the meeting, and they assured me that enough time from the timetable of it happening would give us enough time to respond if it was not, dealt with in the way Mr. Jacobson brought up the fact that the fraud and those type of things are nonviolent, but against what it is we do, and that's what we brought up. But from a timeline perspective, we would have enough time at our May board meeting to change our position because of the timeline that it takes to put this through, so.
Yeah, and I know boards like ourselves, we track who supports and who opposes, not who watches, right? And so, if anything, it would get others' attention on a particular aspect of this, but if that's going to hurt our opportunities to proactively work with the author's office, then certainly I'm not suggesting we change on that basis, but I just wanted to reiterate the question that was kind of asked and answered in the committee, but just at a full board level here to make sure we're all comfortable with that watch position.
That was my understanding excuse me, Mr. President, at the committee level, was that this position would facilitate our ability to work with the author. No. And we would have time to change if necessary.
Okay. So I'm supportive of this. It's just, I think our communication needs to be pretty direct and explicit about the grave concerns we have about the language in there.
I agree.
Yes, sure.
So with the watch position, we also could include not only staff proactively working with the authors, but a letter. We could send a letter to the author as well so that it is documented. But if it's the pleasure of the board that an oppose unless amended position is the preferred position of the board, I believe the author and staff would still continue to work with us. So I don't think that alone would eliminate the proactive work we would do with the author's office.
Which would be better from the proactive end of things?
There's different perspectives or issues that you would have to consider. I think one of the benefits and the reason staff came forward with the watch position is wanting to maintain a cooperative and effective relationship with the authors in the future. And so I think that was part of the motivation for the watch as opposed to an opposed position. But that doesn't necessarily override the consumer protection issues, and so it really is the pleasure of the board.
So I know we have a motion. Should we?
Well, I want to see if there's any more comment or
Yeah.
discussion. We can vote on this motion, and if it does not pass, we can initiate another one. So, any public comment on this issue? Call for a vote, please.
Alicia Burhow,
Yes.
Jose Campos.
Yes.
George Familet,
Yes.
Dan Jacobson,
Yes.
Sochi Leon,
Yes.
Luz Molina Lopez,
Yes.
Corolla Nicholson,
Yes.
Michael Savoy,
Yes,
and Kathleen Wright.
Yes.
motion carries. Thank you. Next item.
Moving on to AB 2483, Department of Consumer Affairs, Office of Supervision of Occupational Boards. This bill would establish an Office of Supervision of Occupational Boards within DCA to exercise active supervision over a covered board, including ours, to ensure compliance with specific policies regarding licensing and enforcement. Currently, our boards within DCA act as a semi-autonomous entities. The decisions of the boards with respect to setting standards, conducting examinations, approving candidates, and revoking licenses are not subject to review by the director of DCA. CBA staff met with the author's office last week, and the legislative staff stated they would like to work with DCA boards on the bill. The legislative committee recommends that the CBA take an opposed position on this bill and direct staff to convey the CBA's concerns in its opposition letter.
Thank you. Any discussion, any comments, any questions? Any public comments? Call for a vote, please.
Kathleen Wright,
Yes.
Michael Savoy.
Yes.
Carola Nicholson.
Yes.
Luz Molina Lopez.
Yes.
Sochi Leon.
Yes.
Dan Jacobson.
Yes.
George Pamela.
Yes.
Jose Campos.
Yes.
And Alicia Burhouse.
Yes.
All right, moving on to AB 2958, State Bodies Meetings Teleconference. This bill will amend provisions of the Bagley B&K Open Meeting Act with respect to teleconference locations. This bill will require that all state bodies conducting a meeting by teleconference do the following. Number one, list the member participating via teleconference in the meeting minutes. Number two, designate a primary physical meeting location. Number three, include the teleconference phone number and website in the agenda to indicate how the public can access the meeting remotely. And number four, on and after January 1st, 2019, prior to holding a meeting by teleconference, a state body shall adopt teleconference regulations. Currently, the CBA lists the teleconference location when applicable in all the meeting agendas. The meeting minutes indicate whether a member was present, but does not specify whether they participated via teleconference or not. The CBA does not have teleconference regulations, and adopting new ones would take approximately 18 months. During this time period, the CBA will be prohibited from holding a meeting via teleconference. The Legislative Committee recommends that the CBA take a watch position on this bill.
Discussion, questions?
Just a question to clarify. The reference here to teleconference, is that webcasting or is this just a phone line? I was a little confused. In other words, are we teleconferencing right now?
No. We are video web.
Or web.
Webcasting, so it's either one or the other.
No, it's for,
Please do.
when you have a teleconference, it's someone participating at another location
Right.
via electronic means.
Right.
So in most cases, it's going to be via telephone. So say you were one member and you were at your office, let's just say.
Right.
You would be at a teleconference location.
That I understand, but where I'm a little unclear is, apparently CBA uses this, and I'm uncertain as to when it is that we use it. Is it at the subcommittee meetings that are held in Sacramento? That is a teleconference?
That's more a question, I think.
And we've used this in the past, and it's been very rare.
Yeah.
What we did, for example, one time we had some very sensitive legislation that we had to make a decision on, and we did a teleconference at a former board member's place of employment. We noticed the meeting and had to do it that way. So we've done this before, but it's very rare.
Would then this bill encompass the more sophisticated conferencing software that is now available and used widely throughout industry?
Yes, this would. Any sort of electronic teleconferencing, this bill would impact that.
Jose?
So question, two questions. One, if I understood what was just indicated, one of the drawbacks we've had to doing teleconference remote access has been if for some unforeseen reason, one of the teleconference locations does not have that participant after all, that it invalidates your meeting. I didn't hear that in what was described right now. Would that rule still apply, or would you get relief from that?
It would still apply.
It would
Based
still
on my
apply.
reading of this, yes, it would still apply.
It would still apply.
Yeah. It kind of makes the teleconference requirements a little bit more stringent in the sense that you have to say who it's going to be 24 hours before the meeting.
Okay, so it's adding more layers to so it's not making
Yes.
anything easier, it's making
No.
things
Yes.
harder.
Welcome, Kelly.
Why, and then you're adding the added bonus that if you try to adopt this and adopt some regulations, you can't do anything in the interim, because we've done this with the MSG committee.
Yeah.
Right.
Why would that be the case? I didn't understand that.
I wish I could answer that question for
Okay.
you. It's just, if they want the regs in place by, or on or after January 1st, 2019, basically, in order to have the regs in place by the time this statute would go into effect, we will have had to start this reg process 6 months ago.
Okay,
So, because the process is about 18 to 24 months.
who comes up with this stuff? All right, thank you.
You can
I
see,
don't
you
think I
can
wanna
see the
see
name
it.
of the
Yeah.
person on there.
Yeah, who's the author? All right, anything else?
Any other questions, comments? Call for a vote, please.
Alicia Burhow.
Yes.
Jose Campos.
Apologize. The motion is what?
To watch.
To watch.
To watch. No.
Okay.
George Familet.
Yes.
Dan Jacobson.
Yes.
Soshi Leon.
Yes.
Luz Molina Lopez.
Yes.
Corolla Nicholson.
Yes.
Michael Savoy.
Yes.
And Kathleen Wright.
Yes.
Motion carries.
All right, moving on
Next item.
to SB 921, State Agencies Internet Website Disclosure of Financial Information. So this bill would require any state agency that maintains and operates its own website to post the number of employees, the total budget, and the sources of its funding for the current and preceding 5 fiscal years immediately below the heading on the homepage of its website. Currently, the CBA homepage displays its mission and vision statement, announcements, links to information regarding licensing and enforcement programs. The information specified in this bill is already publicly available and in various publications such as the CBA Annual Report, the CBA Strategic Plan, and the Update. These resources are all available on our website. The Legislative Committee recommends that the CBA take a watch position on this bill.
Questions, comments? Public comments, call for a vote, please.
Kathleen Wright.
Yes.
Michael Savoy.
Yes.
Corolla Nicholson.
Yes.
Luz Molina Lopez.
Yes.
Soshi Leon.
Yes.
Dan Jacobson.
Yes.
George Familet.
Yes.
And Alicia Burhow.
Yes.
Motion carries. Next item.
SB 984, State Boards and Commissions Representation of Women. This bill will require that the composition of boards and commissions throughout state government be at a minimum 50%. In the last 7 years, the CBA membership has been at least 50% women. This bill would not impact the CBA's current composition, which is 9 women out of 15 appointees. The committee decided and recommends that the CBA take a watch position on this bill.
Yes.
I have a question. What would be the punishment if, I mean, I'm not worried about our board, and quite frankly, the governor has made a very big deal about making sure that all of our state boards and commissions are 50%. Same thing with the speaker, same thing with the pro tems. So what would be the punishment if these boards and commissions don't have 50%? Because we still have women who won't apply for a lot of these boards and commissions.
That's a good point. I have no idea what it would be because it's not specified in the proposed language, so we don't know. But it's possible that because of this, that they wouldn't be able to be appointed. So it would hold you back in that regard.
So basically, if there are no women that are applying or are available to appoint, if we appoint a male, will we get punished for that? Because I mean, I'm concerned about quorum issues.
No, and you're right to be concerned about quorum issues, but I'm wondering if this statute would prohibit even the appointment of that gentleman.
Okay.
Which would still result in
And I think
potential
that-
quorum issues.
Exactly.
Right.
So
This is my-
you're
this
still
is
running
my
into the same
question.
problem. It's
Right.
just which direction do you want to approach it from, but yeah.
So I feel like this is a solution in search of a problem when, again, the governor and the speaker and the pro temp have all made it very clear
Bless you.
we're going to have 50% women on our boards and commissions.
That's why we're probably taking a watch position,
Okay.
see where it goes. Yes, Kathleen?
The question I have is this constitutional? I mean, in the academic environment, we're not allowed to set quotas. That was struck down long ago by the Supreme Court as unconstitutional. This would appear to be a quota.
Yeah.
Well, and you know, you do make a good point on that, but unfortunately, state agencies don't have the authority to say whether something is unconstitutional or not. It has to come from an appellate court or higher.
Yeah.
So even if it is, let's just say, for argument's sake, that it is unconstitutional, the CBA wouldn't be able to not follow it because they think it's unconstitutional. They would have to wait until a court, an appellate court or higher, determines that it is unconstitutional.
All right. Comments, questions, public comments, please call for a vote.
Alicia Burhow.
Yes.
Jose Campos.
Yes.
George Familet.
Yes.
Dan Jacobson.
Yes.
Soshi Leon.
Yes.
Luz Molina Lopez. Corolla Nicholson.
Yes.
Michael Savoy.
Yes.
And Kathleen Wright.
Yes.
All right, moving on, SB 993, Sales Tax Services. This bill would impose an unspecified sales tax on the purchase of services. This bill will exempt healthcare services, education, childcare, interest and insurance payments subject to gross premium tax, and a business with gross receipts of less than $100,000 of the previous four quarters. This bill does not have an impact on CBA's mission of consumer protection. However, it would broaden the tax base by imposing a sales tax on services, including those provided by CPAs. In 2015, a similar bill, Senate Bill 8, was introduced by the author. The CBA took a watch position on this bill and it failed passage. At this point, the Legislative Committee recommends that the CBA take a watch position on this bill.
Comments, questions?
Why not oppose it? Why not oppose it?
What was our reasoning? We discussed it pretty lengthy yesterday.
Because it didn't have any direct impact on our role of consumer protection, and that generally, when staff bring forward a recommendation, our focus would be more on what impacts our role in consumer protection as opposed to something that might impact the profession.
I disagree.
Yes, Kathy?
Maybe this should be deferred to future agenda items, but I am not understanding exactly what our role is vis-à-vis consumers and vis-à-vis the constituency that we regulate.
All right.
To me, it would seem we have a duty to both.
We'll write that down. I think consumers come first.
There's a statute in your Practice Act that says when there is any sort of undecided as to what your primary priority is, the statute makes it easy. It just tells you consumer protection is paramount. And every Practice Act has it.
As exemplified by the composition of the board being 7 CPAs and 8 public members, so it doesn't look like we're taking care of ourselves. That's specifically the mandate. Not that anything's ever come down to an 8-7 vote. 8-5 is the closest. But, okay, future agenda item. Any other comments, questions? Call for a vote, please.
Kathleen Wright,
The watch position?
Yes.
Yes, okay, yes.
Michael Savoy.
Yes.
Corolla Nicholson,
No.
Luz Molina Lopez,
Yes.
Soshi Leon,
Yes.
Dan Jacobson,
Yes.
George Familet,
No.
Jose Campos,
Yes.
and Alicia Burhow.
Abstain.
I believe it passes.
Does. I mean, we have 9 people right now?
Yeah.
Okay,
All right.
next item.
Motion carries. Let's move on. SB 1121, Personal Information. This bill would amend the Information Practices Act to revise the definition of business to include any entity that owns, licenses, collects, maintains, and possesses records. According to the DCA legal counsel, this bill does not apply to the CBA as a business. However, this bill would impact CBA licensees, such as sole proprietors, partnerships, and corporations. At this time, the Legislative Committee recommends that the CBA take a watch position on this bill.
Discussions, questions, comments, public comments, call for a vote.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Dan Jacobson,
Yes.
Soshi Leon.
Yes.
Luz Molina Lopez,
Yes.
Corolla Nicholson,
Yes.
Michael Savoy.
Yes.
And Kathleen Wright.
Yes.
All right. Moving on to SB 1159, California Board of Accountancy meeting minutes. At the January 2018 CBA meeting, at the request of the Senate Business Professions and Economic Development Committee staff, the CBA discussed a proposal to exempt CPAs from an inactive license who are current members of the legislature or Congress from the requirement to place the term inactive after their CPA designation. Senate BNP committee staff expressed a willingness to work with the CBA to pursue a legislative solution to the issue via an omnibus bill. The CBA approved the proposal. In February, Senate BNP committee staff informed the CBA staff that at that time, it would not include the proposal in an omnibus bill due to the potential opposition. Immediately thereafter, Senator Murlock's staff contacted CBA staff and advised that he introduced the Senate Bill 1159 as a spot bill to use as the vehicle for the CBA inactive designation proposal previously approved by the CBA. Earlier this week, this bill was amended to include the inactive designation language approved by the CBA. At this time, the Legislative Committee recommends that the CBA take a watch position on this bill.
Discussions?
I think that, excuse me, I think that if they're inactive, they're inactive. And it doesn't matter if they're a member of Congress, a member of the legislature, or a member of the Kiwanis Club. They're inactive, and therefore, I think that that we should oppose.
Any other discussion, questions, public comment, call for vote?
Kathleen Wright,
No.
Michael Savoy,
Yes.
Corolla Nicholson,
Yes.
Luz Molina Lopez,
No.
Soshi Leon,
Yes.
Dan Jacobson,
No.
George Familet,
Yes.
Jose Campos,
Yes.
and Alicia Burhow.
Yes.
Motion carries.
All right, moving on to SB 1371, occupational licensing. This list would add a section to the Business and Professions Code to provide a list of occupational licenses and requires this list to be maintained by an unspecified entity. At this time, the Legislative Committee recommends that the CBA take a watch position on this bill.
Any discussion, questions, comments, public comments, call for a vote?
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Dan Jacobson,
Yes.
Soshi Leon,
Yes.
Luz Molina Lopez, Corolla Nicholson,
Yes.
Michael Savoy,
Yes.
and Kathleen Wright.
Yes.
Motion carries.
Okay, we're almost there. SB 1492, professions and vocations. This bill contains two legislative proposals requested by the CBA to be included in the Senate BMP Committee's omnibus bill. According to the Senate BMP staff, a third proposal requested by the CBA to amend a Business and Professions Code Section 5100 will be amended into SB 1492 at a later time. The Legislative Committee recommends that the CBA take a support position on the provisions of Senate Bill 1492 relating to the CBA.
Questions, comments, public comments, call for a vote, please.
Kathleen Wright,
Yes.
Michael Savoy,
Yes.
Corolla Nicholson, Luz Molina Lopez,
Yes.
Soshi Leon,
Yes.
Dan Jacobson,
Yes.
George Familet,
Yes.
Jose Campos,
Yes.
and Alicia Burhow.
Yes.
And we just included in the package all the other bills that are being monitored by the CBA. It was a written report. This adjourns my update. Thank you so much.
Thank you very much. Moving right along to report of MSG.
Very well. Item 10C2 was discussion and possible action regarding the ongoing role of the mobility stakeholder group. The purpose of this agenda item was to provide the CBA with the opportunity to discuss the ongoing role of the MSG. At its September 2017 and January 2018 meetings, the CBA considered the ongoing role of the MSG in supporting its consumer protection mandate as it relates to mobility. For this meeting, the CBA is being asked to approve the activities associated with the MSG's ongoing role, specifically related to ensuring states are adhering to the enforcement best practices and the disclosure requirements included in the mobility provisions. Given NASBA's work on making determinations over the past several years, its long history performing substantial equivalency determinations, and its access to contacts within the enforcement divisions of other states, staff suggested that the CBA should seek to have NASBA assisted in performing these ongoing determinations. The MSG discussed the importance of understanding the disposition of cases that the CBA refers to other states and to authorize staff to engage in discussions with NASBA to determine whether future updates to the guiding principles of enforcement are warranted. The MSG recommends that the CBA employ a similar process for determining that states continue to operate under substantially equivalent enforcement best practices, include as part of its evaluation 2 additional criteria. One, whether states in a timely manner and adequately address enforcement referrals by the CBA, and two, whether the state imposes discipline against licensees that is appropriate for the nature of the alleged misconduct. Also, direct staff working with the MSG chair to contact NASBA to gauge its willingness in assisting the CBA in these ongoing determinations, and at a minimum, NASBA provide a scope of work/methodology for conducting a state-by-state review, taking into account the additional criteria. Evaluation of states' continued disclosure of disciplinary information, a time frame for conducting its review, its process for evaluating the guiding principles, and its plans on considering revisions and exposure for any revisions, and any additional information it deems relevant for CBA consideration. And finally, as part of this very long motion, request that NASBA, should it agree with assisting in the determination process, to provide the above identified information to the CBA for its consideration at the July 2018 meeting.
Does that have to be the longest motion I've
Ever.
ever? Regardless, any questions on, if you, comments?
If you wish, I could break every bullet point on it to a separate motion.
I was going to say, do you have an acronym for that, so we can cut it down? Any public comment, please call for a vote.
Alicia Burhouse?
Yes.
Jose Campos?
Yes.
George Family?
Yes.
Dan Jacobson?
Yes.
Soshi Leon?
Yes.
Luz Molina Lopez? Yes. Corolla Nicholson?
Yes.
Michael Savoy?
Yes.
And Kathleen Wright?
Motion carries. Next item.
Thank you. Item 10C3 was discussion regarding the mobility activity report. Staff reported that the purpose of this agenda item was to allow the MSG the opportunity to review and discuss the creation of a standing mobility activity report. Staff presented a draft version of this report with statistics from previous MSG annual reports. The MSG discussed this report and suggested that in the future it be updated to also include a section for NASBA developments related to mobility, peer review, matters that might impact mobility, and internet disclosure, given the importance of it in the original law. I think it was already referenced earlier, some of the reshuffling of information out of the enforcement report into the mobility activity report, and then there will be some additional things that will kind of come into play with it going forward. This was informational, and there was no action.
Thank you.
Item 10C4 is discussion and possible action regarding stakeholder objectives related to the MSG. The purpose of this agenda item was to provide the MSG the opportunity to discuss and take action regarding the stakeholder objectives, which were previously established in 2014. The MSG discussed and decided to include one additional category, and thus the MSG recommends that the CBA direct staff to add to the stakeholder objectives the internet disclosure of a licensee's disciplinary history.
Any discussion, questions, comment, public comment? Call for a vote, please.
Kathleen Wright?
Yes.
Michael Savoy?
Yes.
Corolla Nicholson?
Yes.
Luz Molina Lopez? Yes. Soshi Leon?
Yes.
Dan Jacobson?
Yes.
George Family?
Yes.
Jose Campos?
Yes.
And Alicia Burhouse?
Yes.
Motion carries. Thank you. Item number 11 is the approval of minutes. Can I get a motion to approve the minutes, specifically agenda items 10A through H?
So moved.
I second that.
Any discussion, questions?
I have a question. Some of these minutes I have to abstain from, and some of them I am able, I did participate, so would I abstain in total?
Yes.
Yes. Any other? Yes.
Yeah, there was one, let me find it, the officers that were listed in the summary on page 1 of the minutes, I have it right in front of me, were off. Let me find my version.
It's on,
You see it?
yes, I'm sorry, it's on the very first page.
That was the only edit. So just, the attendees were all appropriate, it's just the listing of who the officers were for the meeting. With that edit.
I will accept the friendly amendment, the friendly edit. Uh-oh.
Sorry, I didn't catch that. Mark didn't change. Okay, so with that, any other discussion, questions, comments, public comments? Outside of the amendment to the motion, call for a vote.
Alicia Verhow.
Yes.
Jose Campos.
Yes.
George Familet.
Yes.
Dan Jacobson.
I'm sorry, was the thought that if we were not at a meeting that we should abstain?
Yes,
Yes.
yes.
Well, I abstain.
Xochitl Leon.
Yes.
Luz Molina Lopez.
Abstain.
Corolla Nicholson.
Abstain.
Michael Savoy.
Yes.
And Kathleen Wright.
Yes.
Sorry, I'm doing the math. At least on the January 18th minutes, because we only have 9 people present who were at that meeting, and if Dan and Luz Molina Lopez don't vote on it, they abstain, we may not have enough votes.
Shall we bifurcate the
Oh, no, you're right, you're right.
motion? and-
You're right,
No, we've had
sorry,
it.
sorry,
We okay?
sorry. Yeah, we're good,
Yeah.
sorry.
Cal-
Math.
Give her the calculator.
No,
Give
no,
me
no,
yours.
we're
I
good.
call math.
I was gonna put a
Sorry.
calculator forward, but
They always
One-
told me you're never
one
gonna have to do
clarifi-
math, and they lied.
one clarifier question.
Okay, we're good.
We said if somebody wasn't present at a meeting, that they can't vote on the minutes? I thought if you weren't on the board, certainly you would be required to abstain because you weren't a member for those. But, we approve qualification committee minutes.
Well, there's a difference between approval and adopting.
Okay.
So when you're at the meeting and you're voting on minutes, you can't say, yeah, I agree with these minutes because I wasn't there. Versus
Okay.
when you have the committee meeting minutes that have already been adopted by the committee itself and they come to the board for approval.
That's a great
different-
clarification.
that's
So,
a different
so
thing.
the only adoption here is of the main, the CBA minutes. Everything else is an acceptance.
Yes, that's correct.
And so there's a difference, so to adopt, you physically should have been there.
Yes, because otherwise you wouldn't know if something's wrong on it.
So going forward, I guess we should maybe split those up,
Yeah,
I mean,
I
in the
agree.
event, so that we don't
idea.
have that particular issue that we just ran into.
Okay.
Sorry, that's great, though, I didn't realize that.
Item 12A, is there anything on the American Institute of Certified Public Accounts? No? Good. That brings us to closing business. Any public comments? Any agenda items for future board meetings? You've already brought one up. We've written that down. Do you have another one? No. Okay. Mr. Jacobson?
Yes, I have, and I've communicated extensively with Carl about this, but I believe that in the past, there's been issues, and I know that Carl did a 2014 presentation to the board as it was constituted at that time regarding the requirement that any behavior upon which action is taken by the board has to be substantially related to the practice of accountancy. And actually, there's the practice is broken down into 3 different categories. Duties, and I can't remember the other 2 off the top of my head. But Carl's been very kind to send me his 2014 presentation. I have done some independent research. Obviously, I am not the board's lawyer, I'm not staff's lawyer. I am a lawyer, but I'm a member of this committee. I think that the board, I'm a member of this board. I have come to a differing conclusion than Carl did, and I would like to give a presentation on why I came to that differing conclusion, so that the board can see a different perspective and proceed as it deems appropriate.
So what I suggest is you can have an off-the-record conference with our
That's what I was going to
attorney,
suggest, if you don't mind.
with her, to see if it's even appropriate to bring before this, or to get better clarity of where, our parameters are in having this. We had this for many years where our resident liberal would say, what does that have to do with the profession of CPA? And so discuss it with her first.
So let's you and I connect, and then I'll let Patty know if you still want to have it on the agenda after that.
That sounds perfect.
Okay, perfect,
Thank
great.
you
And
very
then
much.
maybe Carl can be invited to the conversation as well.
Please.
Just to be clear what that agenda topic was, this is sort of crimes that are substantially equivalent to
They're substantially.
duties of a CPA, right? That's the topic.
Yes.
Yes.
Yeah, we've had that topic on the agenda before, but that was probably before
Wait,
many of the
many
board
board
members were here, so it might be
Appropriate.
appropriate to have a refresher.
Okay.
Okay, any other agenda items? With that, we go into closed session. Thank you all. Okay, we're back on the record after closed session. Thank you all for attending. This meeting is adjourned.